Hello friends, on Monday Arvind Tiwari, the petitioner in the ICSE board examinations case, also the parent of an ICSE class 10 student, will give his response to the affidavit which was filed by the Council for the Indian School Certificate Examination, and he will also respond to the points which were raised by the Maharashtra government. Now before I proceed, please listen to this video very carefully because it contains a lot of legal jargon. So any point you don't understand, rewind and listen to it again, and I will go through it very slowly. Now, point number one, an important development which has taken place is that a notice has been issued by the Bombay High Court, which says that the division bench of the High Court, consisting of Chief Justice Dipankar Datta and Justice S.S. Shinde, will take up this public interest litigation, that is PIL, pertaining to the ICSE exam case at 10:30 a.m. on Monday via video conference. So usually the sitting is between 10:45 a.m. and 1:45 p.m., right? And the case would ideally have to await its turn. But by posting the hearing for 10:30 a.m. before the regular session starts, the court essentially, to my mind, has indicated that it deems it important for a swift hearing and also possibly a verdict, right? Now on Friday evening, I had brought before you the contents of what the ICSE Council had said in the court via its affidavit. Many of you felt that the points made by the ICSE Council were rather strong and that it will be very difficult to counter them. Now I just want to put before you certain facts, and it's for you to decide where the case can actually proceed from here on. One of the first objections which was raised in the ICSE affidavit was that the petitioner Arvind Tiwari is a private individual, since his son is an ICSE class 10 student and therefore not fighting a public cause. They also made the point that he is neither a registered association nor any kind of a body which is representing students or parents. They also made the point that if he was indeed fighting in public interest, he should have also mentioned the CBSE, which is also conducting the examinations during the same 2-week period in the first 2 weeks of July 2020, right? Now let's just step back and examine what happened in the Telangana and Madras High Court, which according to me are very strong and relevant legal precedents. There also PILs, public interest litigations, were filed against the Telangana and the Tamil Nadu governments respectively against the conduct of the state board class 10 examinations, board examinations. In Telangana, one of the PILs was filed by a gentleman called M. Balakrishna, who is a faculty in an educational institution in Telangana, right? What happened in the Madras High Court? The first PIL, and listen to this carefully, the first PIL was filed by an advocate called Stalin Raja. Now, like Mr. Tiwari, Stalin Raja is also the parent of a class 10 student. However, and I spoke to him this morning, however, he said in order to show that he was speaking on behalf of 9 lakh students, he did not mention in his affidavit that he was a parent. The court rejected the PIL because they told Stalin Raja that you are appearing just as an advocate. You are in no way connected with this entire issue or case, right? So the PIL was rejected. The court subsequently admitted 2 PILs, one filed by the Tamil Nadu Teachers Association, another one by Students Federation of India. And it is finally these PILs which were heard, and during the hearing, the Tamil Nadu government asked, the Madras High Court asked the Tamil Nadu government to say whether they can give an undertaking that each one of those 9 lakh students who appears for the exams will be safe and not test corona positive in the future. The Tamil Nadu government cancelled the exams. Now, if the bench at the Bombay High Court wanted to dismiss Mr. Tiwari's PIL, it would have done that on Friday itself if we are to take Stalin Raja as some kind of a precedent. It admitted the petition. It also allowed the hearing. It allowed the ICSE Council to have its say. It allowed the Advocate General representing the government of Maharashtra to have his say, which means they're okay. It seems to me that they're okay with the legal standing of the public interest litigation. See, basically, if you speak to a lot of lawyers, they will tell you that it depends to a large extent on the judges themselves. They examine the issue whether the issue is in larger public interest or not. There may be some gray areas whether X or Y or Z is good enough to represent this particular issue or not. But if the issue is in the larger public interest, they generally go ahead with it. In fact, there have been cases where they sometimes dismiss the PIL but take suo motu cognizance of the issue. You understand? Suo motu cognizance means the court itself decides to take up the issue without waiting for anyone to file a petition. Or it could also ask the petitioner to convert it into a writ petition and bring it before the same court. That also has happened in several cases. Also, remember that the larger point is that Mr. Arvind Tiwari, unlike Stalin Raja's affidavit, his PIL mentions that he is filing this PIL for the sake of his child, for his son, and also for all the children who are 10th standard students of the ICSE board. So he has also made this larger point. Now let's come to point number 2. The council mentioned that it conducted an online poll among 196 of the 226 principals of ICSE affiliated schools in Maharashtra, and 84% of them said exams should be conducted. Now, as I said in the video on Friday, principals ought to have elicited the opinion of the parents before committing themselves on behalf of the students and the parent community. Point number 3, and this is important. The other important point that was made was that ICSE said it follows the instructions of the central government and the Ministry of HRD, and therefore the Maharashtra government by implication cannot stop it, right? It said that the directives given by the additional chief secretary in charge of school education cannot override what the Government of India, the Ministry of Home Affairs and the Ministry of HRD says. The point to the contrary is that I know it for a fact that in every state, be it Telangana or Maharashtra or Tamil Nadu or Bengal or Odisha, be it any state, every school gets some kind of a no objection certificate for running the school from that particular state government. Because whether it be for land allotment, for establishing the school premises, or for power supply, or for water supply, or for some kind of a municipality certificate, property tax, all that happens in a relationship with that particular government of that state, not with the central government of that state, that government. So it's important that every educational institution at any level is also recognized by some wing of that particular state government, so to say that we are not in any way governed by a particular state government may be a bit erroneous. Okay, so these are the facts on some of the points which have been raised by the ICSE Council. The learned judges will continue the hearing on Monday morning, and hopefully we may have some kind of closure on this issue tomorrow itself. So let's look forward to what happens in court in the Bombay High Court tomorrow, and tune into Study with Sudhir, because we will be bringing you the latest happenings from the courtroom, the most reliable information, the most accurate information right here on Study with Sudhir. Thank you very much for watching.